Well, thank you all for coming out to this press conference. We thought it was very important to assemble media here today because we strongly disagree with the information that's being disseminated against Michael Hollingsworth, our client. First, it's important for me to emphasize that Hollingsworth is not responsible for deploying any bottle bombs in the Magic Johnson Theater. Manuel Joyner Bell Jr. acted alone, totally and completely. This is evidenced by the videotape recently seen on television, as well as other evidence that we're aware of. Upon our investigation, it appears that the so-called bottle bomb used in this case was anything but. Apparently, they had contained a mixture of baking soda, which is sodium bicarbonate, white vinegar, which perhaps may be classified as a mild acid, and aluminum foil, which is a catalyst to speed up the reaction. Hardly a harmful chemical or a combination of harmful chemicals. When these products are sealed in a plastic container and shaken, it releases CO2. The pressure from the CO2 causes the bottle to rupture and make a very loud noise. In other words, it's a ruptured pressure vessel, not a bomb. It is no more harmful than an overpressurized helium balloon, and when it ruptures, the noise is quite similar to a ruptured helium balloon due to overpressurization. It was not a weapon. It was never intended to be used as a weapon. It was not harmful. It did not harm any person or property, and it certainly was not a military ordinance. The materials involved don't even become explosive until they're mixed together. And when they are mixed together, it normally detonates within 2 minutes. Any one of the materials involved, when isolated, are merely common household items. There is no evidence whatsoever that Hollingsworth manufactured or possessed a destructive device. There is no evidence that Hollingsworth assembled or mixed these substances together to cause or create a destructive device. There's no evidence that Hollingsworth threw or deployed a destructive device or military ordnance. It did not disperse any plastic shrapnel. It did not disperse any harmful metals or any other type of projectile of any sort. There's no evidence that Hollingsworth caused or intended to cause the assault or battery of any of the people involved in this incident. My investigation further revealed that the police department violated my client Hollingsworth's constitutional rights under the Fourth Amendment by obtaining the contents of his cellular phone without a warrant. This content included text messages that were misconstrued and taken out of context by authorities to give the impression of some collusion that was non-existent in this case. We have filed motions to suppress this evidence. Last, our investigation revealed that the pressure vessel used in this case constitutes a firework under the public safety article. It's definitely a firework more so than a destructive device. It was an implosive, I'm saying it was a firework because it was an implosive composition of substances prepared to produce an audible effect. It did not require any explosions of any kind that required any type of fire or anything combustible. None of these substances mixed together were combustible. They merely were, basically it was a loud noise thing. So we wanted to set an example or make an example to the state's attorney's office not to overcharge individuals and blow these types of cases out of proportion for political purposes. This is not about politics. Most of the elements in the serious charges of this case do not involve fear whatsoever. When you strip away the fear in the histrionics and the hyperactivity that surrounded this case, and you pull back the layers, and you deal with the actual law and the facts, you will find that this was nothing more than a prank, a very silly prank nonetheless, but it was a prank that was conducted by Joyner Bell all by himself and did not in any way involve my client, Michael Hollingsworth. Thank you.
Could you say and spell your name for us?
My name is J. Wyndal, W-Y-N-D-A-L, Gordon, G-O-R-D-O-N. And also with me is Jason Timoll, and he can tell you how to spell his name.
Jason, Jason,
My law clerk is with me, Ms. Ariana Lenoir.
A-R-I-A-N-A, last name is Lenoir, L-E-N-O-I-R.
And additional co-counsel is next to her.
Raouf Abdullah, R-A-O-U, F as in Frank, Abdullah is Apple, Baker, David, U-L-L-A-H.
I'm curious, at one point you're asserting your client's innocence in these events.
That's correct.
But you also, at the end, called them pranks. Why is it that you're calling them pranks? Certainly theaters emptied out and people were, to some degree, terrified of them. What do you gain by calling them pranks?
Because this was something that a silly person did who wanted nothing more out of the situation than laughs. His intentions were not to cause fear. His intentions was to cause a disruption. And that's what he caused. Now, in this day and age, you cannot do things like that. But whether it's a prank or no prank, it has nothing to do with Michael Hollingsworth, who was not involved in it whatsoever. And I think the evidence is going to bear that out. The only thing that my client is guilty of is having a friendship with Manuel Jr.
Do you wish to talk about the motion anymore?
The motion to suppress? The motion to suppress is derived straight from the recent Supreme Court decision of Riley versus California, where the Supreme Court says that if you're going to take someone's cellular phone and obtain the content of the cellular phone, you must get a warrant. And incidentally, it's so wonderful that the case came out because we were going to challenge that before the case came out. But when it came out, it just provided us with the necessary authority. So we believe that we should be successful in having that evidence suppressed.
Around the incident when it happened?
He was not even in the same movie theater. And when I say same theater, well, cinema, whatever the movie rooms are called, they were in totally separate cinemas. And my client wasn't even sitting with the other gentleman.
Did they come in together, or I mean, were they?
Actually, no, they did not come in together. They arrived together, but they did not come in together. My client went to see, I believe it was X-Men, and he went and found himself a seat, and the other gentleman went to whatever movie he attended, and then left that movie to go into this other movie theater to deploy his pressure vessel.
They arrived in the same car?
They arrived in the same car. There's no crime in that.
Do you just think purely coincidence that they were going to be there at the same time?
No, they arrived in the same car. That's not a coincidence. They arrived, they came together.
And they then left in the same car too?
Well, they couldn't spend the night there. And see, that's the thing. I don't want people to misinterpret the fact that they left together. That they can't stay there all night. Okay, they have to go home. They didn't rush out of the movie theater. You don't see anybody scampering to their car after the events. They left when everybody else left, and they walked out with everybody else.
Thank you.
Thank you.